The trapper was kneeling beside a wire cage on my wooded lot when I caught him reaching for a second baited door. An HOA utility cart blocked my logging trail, its orange beacon flashing against the pines. Wet leaves clung to his boots, and something inside the covered cage rattled the handle. He pointed at the Alder Ridge HOA logo on his work order and said, "This whole greenbelt is under contract. Step back." I did not touch the cage or block his exit. I photographed his license plate, the numbered trap tag, and the pink boundary ribbon above his shoulder, then asked him to read the parcel number on his authorization. He looked down. The work order named Common Area B, an HOA parcel ending at the drainage easement, nearly 400 feet behind us. My lot number appeared nowhere. His confidence vanished, but the real surprise came when he radioed his supervisor and asked what to do about the other 7 cages. 7. This was not one mistaken step across a boundary. Someone had mapped a trapping route through the deepest part of my land, and I needed to know who approved it, what they had already removed, and why the HOA wanted the work hidden under tree cover. My name is Caleb Rowan. I was 52 that spring, and Rowan Woods was my 38-acre family property. The trail, survey cap, and surrounding trees belonged to me. The man introduced himself as Owen Keller from Pine Ridge Wildlife Solutions. He kept glancing between the work order and boundary ribbon. I was given coordinates, he said. I asked him not to move anything until his supervisor confirmed the locations. Owen inspected the covered cage, folded his gloves into one hand, and left without arguing again. After his cart backed toward the HOA side, I photographed the ground before following the tracks. The tires had pressed twin dark channels through the wet needles. Beside the first cage, bait had been scattered under a cedar. A white plastic sack corner protruded from the leaves. Farther downhill, another numbered cage sat behind a fallen oak, well inside the line marked by my father's old steel posts. I stopped counting after 3. Each location went into my phone with a timestamp and a wide photograph showing the nearest boundary feature. After 26 years teaching high school biology, I knew not to handle an occupied trap or compromise the evidence. The tracks continued toward the habitat pond my father and I had restored by hand. That bothered me more than the cart. The pond sat in the quietest pocket of Rowan Woods, beyond any place an HOA contractor could reach by accident. When I returned to the entrance, I examined the chain across my trail. From a distance it looked locked. Up close, one link had been cut cleanly and tucked behind the post, while the padlock hung untouched from the loose end. Someone had opened the trail, driven through, and arranged the chain to make it appear secure. I took one last photograph. In the wet soil below the gate were several overlapping tire impressions, some softened by earlier rain. Owen had not entered for the first time that morning. I went back to the pond before the rain softened anything else. The trail narrowed after the second bend, where cedar roots crossed the soil, and my father's steel posts appeared between the trunks. 40 years earlier, he had placed them as practical reminders of where our work stopped and the neighboring farm began. Rowan Woods had existed as its own 38-acre parcel long before Alder Ridge. My father, Samuel, bought it from a retiring timber family when I was 12. The tract had no grand house and no paved entrance. It had a rough logging trail, a spring-fed creek, and a silted pond that flooded every hard rain. He spent weekends teaching me how to read that land. We cleared storm debris, replanted the creek bank, and rebuilt the pond outlet one stone at a time. After he died, I kept the property because selling it felt like erasing a language only the two of us had spoken. A developer later bought the farm surrounding our eastern boundary and built Alder Ridge. My father refused 3 purchase offers. The recorded subdivision plat curved around Rowan Woods, leaving our parcel outside the HOA. The only right Alder Ridge received was a narrow drainage easement across the northeast corner where a buried culvert carried runoff beneath an old access strip. It allowed inspection and maintenance of that drainage feature. It did not turn the remaining woods into community land. Near the pond, I found a flattened patch where a vehicle had turned around. Empty bait sacks lay beneath a canvas sheet. One set of tracks looked fresh, 2 others were wider at the edges and partly filled with pine needles. I checked the trail camera above the pond. Its memory card showed the same Pine Ridge truck entering on 3 mornings during the previous 9 days. Each time, the driver came through my chain trail before sunrise. On the earliest recording, the chain was still intact. On the next, it hung loose against the post. The sequence narrowed when the link had been cut. I copied the files, preserved the original card, and logged every timestamp. Then I emailed Paula Mercer, the Alder Ridge community manager. I requested the signed wildlife control contract, authorized route map, board approval, and the document they believed allowed entry onto parcel 18-442. I attached Owen's work order and a photograph showing the yellow survey cap behind the cage. I did not send the camera footage yet. Paula acknowledged my message within an hour. The substantive reply came from Elise Vance, the HOA president. Her email said Pine Ridge had been retained after residents reported raccoons tearing open trash containers and deer damaging new landscaping. She described Rowan Woods as part of the continuous community woodland buffer and wrote that the HOA possessed authority to perform reasonable nuisance mitigation throughout that area. I read the sentence twice. Continuous woodland was a description of trees, not ownership. The phrase did not appear in my deed, the subdivision plat, or the drainage easement. I replied that Rowan Woods was separately deeded private property, that I had never granted access, and that no HOA employee or vendor had permission to enter. I asked them to preserve every map, email, invoice, instruction, and location record connected to Pine Ridge's work. I also requested supervised removal of the cages after their positions had been documented. Elise answered with 6 words: "Do not interfere with authorized mitigation." By late afternoon, a laminated notice had been fastened to my gate. It carried the HOA seal and warned that interference with wildlife control operations could expose the responsible property owner to administrative charges. I was not an Alder Ridge member. The HOA had no covenant binding my parcel and no ordinary path for charging me. But the notice told me Elise was not treating the boundary as a mistake. At the bottom, beneath her electronic signature, she cited the drainage easement by recording number. I pulled my father's copy from the fireproof box and opened it across the kitchen table. The easement was 4 pages long. Its access language was limited to the culvert corridor in the northeast corner. The pond, the logging trail, and every trap location I had found lay outside it. Someone was relying on a document that did not say what the HOA claimed. Before I answered again, I needed the boundary and every recorded word professionally checked. Renee Alvarez arrived 2 mornings later with a survey tripod, a field controller, and the patience of someone who expected the ground to disagree with the paper. She began at the northeast corner, not at the cages. The yellow cap I had photographed was a known monument referenced in an earlier boundary survey. From there, she checked the deed calls against 2 older iron pins and a stone marker near the creek. The measurements closed within ordinary professional tolerance. By noon, orange flagging traced the eastern side of Rowan Woods. Every cage I had located stood west of that line. The closest was 86 feet inside my parcel. The cage near the pond was more than 500 feet from the drainage corridor. Renee did not overstate what that meant. A survey locates the description on the ground, she told me. It supports where the boundary is. It does not rewrite the deed or decide what legal rights an easement creates. That distinction was exactly why I had hired her. Elise kept talking as if one document gave Alder Ridge every right it wanted. I needed to know how the documents worked together. A title examiner named Walter Kim reviewed the chain of ownership. My father's deed described the full 38 acres. When the neighboring farm was divided, the developer's recorded plat followed our eastern boundary and labeled the land beyond it as Rowan Parcel. No declaration annexed us into Alder Ridge. No later deed conveyed the HOA an interest in the woods. Walter also retrieved the recorded drainage easement cited on Elise's notice. Its legal description formed a narrow rectangle around the culvert in the northeast corner. The easement allowed inspection, repair, replacement, and reasonable access necessary for that work. It said nothing about wildlife control, habitat management, or entry across the logging trail. Renee overlaid the easement corridor, recorded parcel line, camera positions, tire route, and 8 trap coordinates on one exhibit. The visual result was difficult to misunderstand. A slim gray rectangle touched the corner of my land. The traps formed a chain hundreds of feet away, leading southwest toward the pond. Paula Mercer sent the vendor documents that afternoon. The Pine Ridge contract was 23 pages long, including insurance forms and service terms. Its first page authorized nuisance wildlife work across designated community properties, language broad enough to look helpful to a lease if someone stopped reading there. The attached property schedule was specific. It listed Common Area A, a landscaped basin near the clubhouse, and Common Area B, a wooded strip along the eastern drainage channel. Parcel 18-442 was absent. So was Rowan Woods. The official route map carried a green line through those two common areas. It stopped almost 400 feet before the place where I had confronted Owen. I placed that map beside the photograph of the laminated sheet hanging from his pack. On Owen's field copy, a blue patch covered the center of my property. A hand-drawn arrow entered through my logging trail, and 7 red pins curved toward the habitat pond. The angle of the photograph hid the 8th pin, but the pattern matched the locations Renee had recorded. There were now 2 maps, one attached to the signed contract and one used in the field. They were not the same. I called Owen and asked whether Pine Ridge had created the blue shading. He paused before answering. "That wasn't on our original service map," he said. "The route package came from the client. He would not identify the sender without his supervisor's approval, which I understood. Instead, I asked him to preserve the map, his messages, GPS data, trap logs, and work orders. He agreed to relay the request. Renee completed her certified exhibit the next day. Walter issued a short title memorandum explaining that his search revealed no recorded instrument granting Alder Ridge General Wildlife Control access over my parcel. Neither man claimed that their work alone ended the dispute. Together with the deed, plat, easement, contract, photographs, and camera footage, however, they removed every ordinary explanation Elise had offered. I sent the full package by track delivery to Alder Ridge and Pine Ridge. My notice identified each cage, denied consent to any further entry, and offered 2 supervised windows for the vendor to retrieve its equipment without disturbing the documented sites. I gave the HOA 48 hours to withdraw the gate notice and correct its written claim of authority. Pine Ridge acknowledged receipt. Alder Ridge did not. The deadline expired on a damp Thursday morning. At 7:12, my gate camera sent an alert. A larger Pine Ridge truck had stopped outside the chain. Owen sat in the passenger seat. A second technician held a clipboard against the windshield while the driver read the posted notice. They did not cross the gate, but when I walked down the trail, Owen lowered his window and showed me the new instruction sheet. Across the top, beneath the Alder Ridge seal, were 4 words: "Complete the authorized route." I photographed the instruction sheet through Owen's open window. The driver watched me, then looked toward the cut link hanging from my gate. No one moved to cross it. Owen took the clipboard from the second technician and stepped out beside the truck. He said Pine Ridge had been directed to inspect all 8 cages, remove any captured animals according to company procedure, and continue servicing the route. I told him I would cooperate with a supervised removal that preserved the locations, but I would not consent to another unrecorded entry. He called his supervisor. 10 minutes later, the crew turned around. That restraint mattered. The camera showed a vendor arriving under written HOA instructions, reading my notice, and leaving without a confrontation. It also left Elise with no dramatic scene she could use against me. She created one anyway. That afternoon, Alder Ridge residents received a message titled, "Community Wildlife Safety Delay." It blamed an uncooperative adjacent landowner for preventing the completion of a neighborhood protection program. It mentioned torn trash bags, damaged shrubs, and the possibility of animals becoming accustomed to homes. My name was omitted, but Rowan Woods was the only adjacent property involved. By evening, 2 residents had stopped near my gate to photograph the signs. The next morning, someone left a bag of scattered garbage against my fence. I recorded it and cleaned it up. I could not prove who left it, and I refused to turn suspicion into fact. Still, the gesture made the dispute feel less contained. I had spent years teaching students to observe before drawing conclusions. Now I had to practice that discipline while strangers treated me like the obstacle in someone else's story. Paula sent another notice stating that Alder Ridge reserved the right to assess costs caused by my interference. I replied once, "I was not an HOA member, my parcel was not subject to its declaration, and I disputed any claimed charge." I attached Walter's title memorandum and asked that all future communication remain in writing. Then the rain came. It fell through most of Saturday, running along the tire channels toward the creek. On Sunday morning, I found softened bait and fragments of a paper feed sack caught against roots below the pond. Nothing suggested a dramatic contamination event, but the cleanup was real, and the exposed soil around 2 cage locations had begun washing downhill. I hired Dr. Lena Shaw, a habitat restoration specialist, to document the disturbance and recommend limited repairs. Lena spent half a day walking the route with Renee's exhibit. She recorded compacted soil at the turnaround, damaged understory beside 4 cages, discarded bait, the cut chain, and shallow ruts directing runoff toward the creek. Her assessment was careful. The pond was not destroyed. The creek was not poisoned. The land needed debris removal, soil stabilization, reseeding in 2 disturbed areas, and repair of the trail drainage before another hard storm deepened the ruts. That measured conclusion made her report more useful than any exaggerated claim could have been. While Lena worked, Pine Ridge supervisor Grant Mills called me. He said the company wanted to retrieve its cages, but would wait until a process was agreed upon. I asked where the blue route and red location pins had come from. "We received the coordinates from Alder Ridge," he said. "Office transferred them into the crew packet. We did not verify ownership outside the contract schedule." Grant would not assign blame, but he confirmed a basic fact. Pine Ridge had not independently decided that my property was part of the service area. Someone at the HOA had supplied the route. The first sign of who came from Martin Hale, the HOA treasurer. He contacted me from a personal email address and said he wanted the record preserved accurately. Attached was a message he had sent Elise 3 weeks before the trapping began. Martin had reviewed the Pine Ridge proposal and warned that the 2 HOA greenbelts totaled far less land than the proposed service acreage. He specifically identified Rowan Woods as privately owned and wrote that entering it would require my written consent. Elise's reply was brief. Waiting for an outside owner would delay the community-wide sweep, and the drainage easement gave the board adequate operational access. The email did not prove who physically altered the map, but it proved Elise had received a warning before the vendor entered. It also explained why she kept returning to the easement after the survey and title records contradicted her. Martin sent one more document, Pine Ridge's first invoice. The company had billed wildlife control setup across 64 acres. Common areas A and B together contained only 26. The difference was 38 acres, the exact size of Rowan Woods. For the first time, the numbers on the HOA's own paperwork described what had happened more clearly than Elise's words. My entire property had been added to the project, not mistaken for a narrow strip beside a culvert. By Monday morning, I had the survey, title memorandum, camera footage, altered map, restoration assessment, internal warning, and 64-acre invoice arranged in separate folders across my dining table. Another Pine Ridge service date was scheduled for Wednesday. I called attorney Naomi Brooks before breakfast. Naomi Brooks did not call the case obvious, promise a quick victory, or circle the largest number on the invoice. She read the documents in order: deed, plat, drainage easement, survey exhibit, vendor contract, camera log, field map, internal email, invoice, and restoration assessment. She marked every point where one source supported another. "The survey helps locate the cages," she said. "The deed and plat establish the documentary chain. The contract shows what the vendor was hired to service. The communications may show what people knew. We need all of it." That afternoon, Naomi sent preservation notices to Alder Ridge and Pine Ridge. They identified emails, map files, billing records, GPS coordinates, trap logs, text messages, board minutes, camera footage, and every version of the route package. Her cease and desist demand denied any general access right and proposed a supervised retrieval process for the cages. Pine Ridge responded the next morning. Grant suspended all work on Rowan Woods and agreed that no employee would enter while the ownership and route instructions were reviewed. Naomi insisted the suspension be confirmed in writing, with the parcel number and the names of every crew member who had received the route. Grant complied before noon. The HOA's attorney answered 3 days later. Alder Ridge maintained that the drainage easement, community safety obligations, and the woodland's physical relationship to the subdivision created a reasonable right to conduct limited mitigation. The letter withdrew the threat of immediate charges, but refused to correct the gate notice or disclaim future access. Physical relationship was a polished way of saying, "My trees touched theirs." Naomi offered a written standstill: no entry, no trap servicing, no removal except under an agreed protocol, and no public claim that I was obstructing lawful work. Pine Ridge accepted. Alder Ridge agreed only after Naomi prepared a complaint and a request for temporary relief. At an initial court conference 2 weeks later, the parties entered a temporary order barring new entry, while allowing scheduled, documented retrieval of Pine Ridge's equipment. The court reserved every final ownership, easement, damage, and responsibility question. It was not a final ruling, but it gave the woods quiet while the records were tested. The retrieval took 4 hours. Owen and Grant entered with Naomi, Lena, and me present. Each cage was photographed, checked against Renee's coordinates, and removed. Pine Ridge's logs documented 3 prior occupied cage events and the company's handling dates, allowing us to avoid speculation. Watching the last cage leave should have felt like an ending. Instead, the empty rectangle pressed into the grass marked everything still unresolved. Naomi filed claims seeking a declaration that Alder Ridge held no general wildlife control access, protection against future entry, compensation for documented damage, and recovery of expenses where legally available or negotiated. We did not ask for an invented fortune. Restoration, chain repair, survey and title costs, monitoring, cleanup, loss of use, and legal work were recorded separately. The HOA denied intentional wrongdoing. It argued that a lease reasonably interpreted the easement and that Pine Ridge chose its operational route. Pine Ridge answered that it relied on client-supplied coordinates, but acknowledged that its contract schedule excluded private parcels. Discovery began slowly. Weeks passed in production schedules, objections, corrected files, and follow-up requests. My dining table stopped being a place where I ate. It became rows of binders and invoices. Each legal bill made me wonder how much peace a person should have to purchase on land already paid for. Then the original route files arrived. Pine Ridge produced its untouched master map, received with the signed contract. It showed only the 2 green HOA common areas. A later email from Paula's office attached a printable route sheet with Rowan Woods shaded blue. The attachment had been created using an Alder Ridge office account assigned to Elise. Its history showed the blue shape and red pins added the evening after Martin warned that my consent was required. The metadata established when the file changed and which account created it. The surrounding emails supplied context. One message from Elise instructed Paula to send Pine Ridge the complete operational acreage and not to separate the outside woodland from the 2 HOA buffers. Another told Grant that owner coordination had been handled at the association level. I had never been contacted. Martin's meeting notes added another layer. The board had approved wildlife work in common areas A and B. No motion mentioned Rowan Woods, private parcels, or 64 acres. But beside the vote, Martin had written, "Consent required for Rowan tract, not included." Pine Ridge produced Grant's reply, asking whether the additional coordinates were inside the contracted properties. Elise answered that the HOA accepted responsibility for access authorization. Grant then forwarded the route to the field crew without comparing it to the property schedule. That exchange divided the failure rather than simplifying it. Alder Ridge had supplied a route it did not own and claimed authorization it did not possess. Pine Ridge had relied on that assurance, despite a contract identifying only 26 acres. Each side began pointing toward the other. Martin and another director requested a special board session. Paula stopped sending notices. Elise remained president, but her messages now came through council and avoided calling Rowan Woods a community buffer. After 3 months, the court set a mediation date before the next stage of the case. Naomi prepared enlarged versions of Renee's boundary exhibit, the official green route, and the altered field map with 7 visible red pins. On the night before mediation, those 3 sheets covered her conference room wall. Separately, each told part of the story. Side by side, they showed exactly how an HOA contract stopped at my boundary while its vendor kept going. The mediation began at 9 on a gray Tuesday morning. Naomi and I sat on one side of a long conference table with our 3 enlarged maps resting on easels. Across from us were Elise, the HOA's attorney, 2 board members, Grant Mills, and counsel for Pine Ridge. A retired judge named Elaine Park served as mediator. Before separating the parties into different rooms, Park asked each side to state what it believed the case was about. The HOA's attorney framed it as a good-faith response to resident safety concerns. Raccoons had scattered garbage, deer had damaged landscaping, and the woods formed one continuous habitat. He argued that the drainage easement gave Alder Ridge limited entry rights and that Elise reasonably believed those rights, combined with the board's responsibility to protect common property, allowed the vendor's work. Pine Ridge's attorney emphasized reliance. The company had received coordinates and written assurances from its client. Its technicians were wildlife control workers, not title examiners, and they had stopped returning once ownership was formally disputed. Naomi did not argue that the resident complaints were imaginary, or that Pine Ridge should have interpreted every recorded instrument in the county. She narrowed the issue. Alder Ridge owned 26 contracted acres. Rowan Woods contained 38 separately deeded acres. The easement reached one culvert corridor. The vendor entered through a different gate, cut a chain, traveled hundreds of feet beyond that corridor, and placed 8 cages along a route excluded from the signed property schedule. Park asked whether the HOA could identify any sentence authorizing wildlife work outside the culvert corridor. Its attorney could not. He maintained that the language supported their interpretation, but acknowledged that no recorded document named Rowan Woods as a service property. Park divided us into separate rooms. For the next several hours, the evidence moved back and forth in deliberate layers. First came the ownership chain. Walter's title memorandum connected my father's deed to the current record. The recorded subdivision plat curved around Rowan Woods and never placed it inside Alder Ridge. Nothing in the HOA declaration bound parcel 18-442. Next came location. Renee's certified exhibit tied the deed description to the yellow survey cap, older iron pins, creek monument, trail cameras, tire route, and cage coordinates. The closest cage was 86 feet inside my land. The pond cage was more than 500 feet from the drainage corridor. Then came conduct. My camera log showed Pine Ridge's truck entering on 3 earlier mornings. Photographs showed the cut chain, numbered cages, discarded bait, and repeated tire tracks. Pine Ridge's logs authenticated the cage numbers and dates rather than contradicting them. The 4th layer was authority. The signed contract listed only common areas A and B. Its official map ended nearly 400 feet before the first cage. The field version shaded Rowan Woods blue and placed 7 visible red pins beyond the green contract line. Finally came knowledge. Martin had warned Elise that Rowan Woods was private and required written consent. Board minutes excluded my parcel. The revised file was created through Elise's office account after that warning. Her email told Pine Ridge that authorization had been handled at the association level. No single page decided everything. Together, the records left the HOA with a difficult question. Why had its operational map expanded from 26 acres to 64, immediately after its treasurer identified the missing consent? Elise asked to speak before the next private session. She said residents had been demanding action for months, and that delays made the board look ineffective. She believed the drainage easement gave Alder Ridge more flexibility than Martin claimed. She admitted directing Paula to include the outside woodland in the operational acreage, but denied intending to take ownership of my land. I thought we were solving one connected problem, she said. I believed that part. The animals did not recognize parcel lines, but vendors and boards had to. Naomi answered that a conservation concern did not become permission merely because the same trees continued across a boundary. Elise had received a warning, skipped the consent step, and represented to Pine Ridge that authorization already existed. Pine Ridge faced its own problem. Grant's email had asked whether the added coordinates were within the contracted properties. That question showed the company noticed the mismatch. It accepted Elise's assurance without comparing the 64-acre route against a schedule naming only 26 acres. Its crew then entered through a chained private trail rather than the mapped HOA access point. By mid-afternoon, both defendants stopped arguing that I had consented. The remaining dispute was how responsibility, restoration, future access, and costs should be divided. Lena's assessment anchored the physical damages. She priced debris removal, trail drainage repair, soil stabilization, reseeding, understory replacement, and follow-up monitoring at $9,600. Renee's survey, Walter's title work, replacement cameras, storage, and documentation totaled $6,200. The cut chain, cleanup labor, damaged trail surface, and documented loss of use added $5,000. My legal expenses had already exceeded those combined figures. Naomi did not claim every dollar was automatically recoverable. Instead, she negotiated a contribution toward fees and a broader settlement consideration that would make continued litigation unnecessary. The final framework totaled $42,800. Alder Ridge and Pine Ridge agreed to allocate the payment between themselves. $9,600 for habitat and trail restoration, $6,200 for survey, title, and monitoring costs, $5,000 for repairs, cleanup, and loss of use, and $22,000 toward legal expenses and negotiated resolution. Money was only one part. Alder Ridge agreed to permanently disclaim any general wildlife control right over Rowan Woods. Future entry would require my written consent, except for access strictly within the recorded drainage easement for its stated culvert purpose, subject to reasonable notice unless an actual emergency made notice impractical. The gate notice and threatened charges would be withdrawn. Residents would receive a written correction identifying Rowan Woods as private property outside the HOA. Pine Ridge agreed to remove my parcel from every service map, attach recorded parcel identifiers to future route approvals, and require written confirmation when client coordinates extended beyond contracted property. Neither side admitted every allegation, but both accepted enforceable duties and financial responsibility. The attorneys converted the framework into settlement documents over the next 3 weeks. The temporary order remained in place while wording was reviewed. After signatures, the court entered agreed permanent relief consistent with the access terms and dismissed the remaining claims subject to enforcement of the settlement. There was no sudden verdict and no courtroom speech. The result came from months of records, measured requests, and evidence that kept matching itself. When Naomi called to say the final order had been entered, I was standing beside the gate with the cut chain in my hand. For the first time since I saw Owen kneeling beside that cage, I knew no HOA contractor could legally return on the same invented route. The restoration began the following week. Lena marked the worst ruts with small flags, while a 2-person crew reshaped the trail drainage by hand. They removed the remaining bait, loosened compacted soil, spread native seed, and placed fiber matting where the slope ran toward the creek. Near the pond, they replaced damaged understory plants rather than clearing a wider work area. I kept every invoice and photographed each repair. Documentation had carried the dispute this far, and I was not going to become careless because the hard part seemed over. The chain at the gate could not be repaired safely, so I replaced it. I kept the cut link in the same fireproof box as my father's deed. Renee installed clearer reference posts near the legal access points, but she warned me not to treat them as substitutes for the recorded monuments. I added signs identifying Rowan Woods as private property and listing a number for legitimate access requests. Alder Ridge sent its correction to residents before the end of the month. The message stated that Rowan Woods was a separately owned parcel outside the HOA, that its drainage easement was limited to the recorded culvert corridor, and that no association vendor could enter the remaining property without written permission. The earlier wildlife safety notice was withdrawn, For the first time, its description of my land matched the records it should have checked before the project. Elise resigned as president after the board completed an internal review. The announcement did not call her a criminal or pretend one decision explained her entire term. It said she had acted beyond the authority approved by the board and had failed to resolve a known property access issue before authorizing vendor work. Martin Hale became interim president. Under his supervision, Alder Ridge adopted a vendor checklist requiring a recorded parcel identifier, confirmation of ownership, a board-approved service boundary, and written consent whenever work extended beyond HOA land. Paula remained community manager but could no longer modify field maps without a second documented review. Pine Ridge made similar changes. Grant sent Naomi the corrected master file with parcel 18-442 blocked from routing. Owen mailed me copies of the final trap logs and a short apology. I believed him when he wrote that he had trusted the work packet. Trust was understandable. Failing to compare it with the contract was still costly. By early summer, grass covered the shallow ruts. The replanted creek bank held through 2 heavy storms. My cameras showed deer moving along the upper trail, raccoons visiting the pond edge, and a fox passing through before dawn. They returned without cages, route pins, or a board deciding that ownership followed the tree line. One evening, I walked to the pond carrying the first photograph I had taken of trap tag number 17. I considered deleting it. Instead, I filed it with the survey, maps, emails, settlement, and final order. Not as a trophy, as a reminder that the first useful thing I did was refuse to turn anger into a scene. I photographed the cage, read the work order, and asked for the parcel number. Every later result grew from that decision. When I reached the gate, sunlight crossed the new chain, and the logging trail beyond it was empty. No utility cart blocked the pines. No covered cage moved beneath the cedar branches. The trail belonged to the woods again, and opening it was finally my choice.